Negotiable Instruments Act, Section 97, when party to whom notice given is dead. Section 97 of the Negotiable Instruments Act, 1881 deals with cases where notice of dishonour is sent to a person who has already died, but the sender is unaware of such death. The section provides that notice given in such circumstances shall still be treated as valid and sufficient under the law. The provision is based on the principle that a person acting honestly, diligently, and in good faith should not lose legal rights merely because he had no knowledge of the death of the liable party. 1. Purpose of the provision. Notice of dishonour is an important legal requirement for fixing liability on parties such as drawers and inducers, but the sender may not always be aware that a party connected with the instrument has died. Section 97 therefore protects the sender where notice has been properly dispatched and the sender had no knowledge of the death of the concerned party. The provision prevents unnecessary hardship and promotes fairness as well as commercial convenience in negotiable instrument transactions. 2. Applicability of the section. The section applies where a promissory note, bill of exchange, or cheque has been dishonoured and notice of dishonour is required to be given to a person who is already dead. Protection under Section 97 applies only where the sender dispatched the notice without knowledge of such death at the time of giving notice. 3. Importance of ignorance of death. The protection is available only where the sender genuinely had no knowledge of the death of the party at the time of sending notice. If the sender had actual knowledge of the death or deliberately ignored known facts, notice sent to the deceased person may not be treated as sufficient. Good faith and absence of knowledge are therefore essential requirements for protection under Section 97. 4. Effect of the provision. Where notice is sent in ignorance of the death of the concerned party, the notice remains legally valid and the sender's rights against liable parties are preserved. Liability is not discharged merely because the notice could not actually reach the deceased person, and the law treats the sender as having complied with the legal requirement of notice. 5. Reason behind the rule. The section recognizes the practical realities of commercial transactions, where negotiable instruments often circulate rapidly and immediate knowledge of the death of a party may not always be available. Without such protection, honest holders could unfairly lose their remedies and technical objections could defeat otherwise valid commercial claims. The provision therefore promotes fairness, commercial certainty, and smooth functioning of negotiable instrument transactions. 6. Relationship with general rules of notice. Ordinarily, where a party liable on the instrument has died, notice of dishonour should be given to his legal representative instead of the deceased person himself. Section 97, however, creates an exception where the sender is unaware of the death, and in such cases notice addressed to the deceased party is treated as sufficient. 7. Commercial significance. Section 97 is commercially important because it protects parties acting in good faith, prevents loss of legal rights due to unknown circumstances, and reduces unnecessary technical disputes regarding notice. The provision also encourages smooth commercial dealings and supports efficiency as well as certainty in negotiable instrument transactions. For more details, contact us.